It's December, so those of you watching the live broadcast may have noticed that today is National Christmas Jumper Day here in the UK. So we've all come armed with our best Christmas jumpers today. So apologies for the colours. Although, Michael, I've got to say, you're letting down the whole of Scotland. That is not a Christmas.
Not really very good, is it? To be fair, it's pretty rubbish. I just don't do them. It's not right. So I just refuse.
Is there a voting function, Trevor, for the best Christmas jumper today or not?
Well, I mean, we could do, couldn't we? Although I'm clearly going to win. I'm clearly going to win. Number one, my colours are horrible, but also if I sit up a little bit more, look, it's an ABBA Christmas jumper. So it's
2-1.
Wins hands down. Anything with ABBA on is a winner for me.
Winner takes it all.
There we are. Anyway, enough about Michael's lack of festive cheer. So welcome to everyone to the December edition of Outline. For those of you who think you're tuning in to listen to us talking about the Levelling Up and Regeneration Act, which was what was originally advertised for this month, that's been postponed to next month because at the back end of last week, we finally, after much waiting, got the draft regulations and various guidance documents in connection with biodiversity net gain. And the biodiversity net gain provisions are now due to come in England, at least in January, at a date in January yet to be revealed. So we thought, given its imminent impact for development, we would reshuffle and talk about BNG today. So if you're here for the LURA, as it's known, then you'll have to wait till next month. I'm afraid we will pick that one up then. But I'm pleased today to be joined by two of my colleagues. Firstly, Henry Jeffries, who's a senior associate in the planning team and our resident guru on all things BNG related. So Henry, great to have you here. And then Michael Greig, a legal director in the team based up in our Edinburgh office. And Michael, you're here today because, of course, as usual, Edinburgh and Scotland is doing sort of what England's doing, but doing it slightly differently. So you're here to point out the differences, aren't you, and tell us.
That's right. Because coincidentally, we've also had a change to guidance as well last week. So again, it seems quite opportune.
Yeah. So we'll get going. Usual format. We'll look to be between 45 minutes and an hour. Definitely no more than an hour. So we will not keep you over time. There's a Q&A box. Please do, if you've got questions as we go along, please do answer them. We'll do our best to pick them up in the discussion. But without further ado, let's talk BNG, and probably Henry as the expert. I'm going to let you kick us off. Just what is it?
Thanks, Trevor. Yeah, so I suppose at a conceptual level, it's the idea that your development leaves biodiversity in a better place than when it started. The idea of biodiversity net gain. I don't think it's anything new in terms of the idea of biodiversity net gain. It's been in the MPPF for some time. And I know that we've seen local authorities in their local plans requiring BNG for some time as well. The key distinction, which I think most people are aware of, is we're now looking at a statutory scheme rather than a policy requirement. So the Environment Act, when it came in 2021, included a number of amendments to the Town and Country Planning Act and the Planning Act 2008 to introduce the requirement for biodiversity net gain, both for 1990 Act development and NSIPs. And today we're going to be mostly looking at the 1990 Act side of things, seeing that's sort of the most imminent side of it. And the way that works in terms of 1990 Act development is it imposes a deemed biodiversity gain condition on planning permissions. So it's there on all planning permissions. It doesn't have to be imposed by the local planning authority. And what that condition does is it says, before you commence development, you have to submit to the local planning authority a biodiversity gain plan and then have that plan approved as well. And the biodiversity gain plan essentially has to set out how the developer is going to achieve the biodiversity gain objective, which is an uplift of 10% in biodiversity value in simple terms. So as Trevor mentioned, we're looking at January 2024 in terms of commencement. I think the latest we've seen is looking at the back end of January, and it's applying to applications that have gone in from that date. So if you make an application before the coming into force date, it won't be caught. If you make it after the coming into force date, it will be caught. There's then a secondary date of April 2024, which is for small sites. And we'll look at that probably in more detail nearer the time. But large developments, we're looking at January 2024. In terms of briefly how you measure biodiversity gain, there's something called the biodiversity metric. And end of last month, we saw the statutory metric published, which is the tool that will be used to measure both the pre-development value and then the value of the proposed post-development habitat. And then in terms of how you deliver biodiversity gain, there are, broadly speaking, 3 options, which are on-site delivery, so as part of the development, off-site delivery, either by the developer themselves or by a third party, and then also the option of statutory credits, which is a government-run regime run by Natural England. So that, in a nutshell, is how it's going to work. There's obviously much more detail that we can get into as we go through.
And I think in terms of the timetable, it slipped and slipped, because this was all supposed to be up and running by now, wasn't it?
Yeah.
But as with so much that comes out of Westminster at the moment, it seems to have been delayed. What we now have is the draft regulations. You're right. I think my understanding is that those regulations are going to go through the parliamentary process at the beginning of January, and therefore it will all come in towards the back end of January. But I think it's just worth sort of flagging at the beginning. We haven't got certainty on that. And that date is critical, because if your planning application goes in before that date, you don't have to worry about the statutory regime. If your planning application goes in after that date, then you do. So if you've got applications you're working up and want to try and avoid having the statutory condition imposed, then the sooner that application is submitted, the better. And certainly by early January, you want to have that application in. So happy Christmas to everyone who's now desperately going to try and get their applications expedited and submitted to avoid getting caught by the regime. Yeah. It's not all applications though, is it? There are quite a few exemptions. There's the small sites exemption for relatively small development. That will come in, won't it? I think, as you said, Henry, but then there are others, for example, sort of NSIPs and such like, that are not going to be caught by this regime. Although in the case of NSIPs, I think I'm right, Henry, it's your bag rather than me, an NSIP, but it's there is a separate scheme envisaged to come later along for BNG, isn't there?
Yeah, there is. So I mean, the date for NSIPs we're looking at the moment at November 2025. So on NSIPs, we've got the provisions in the Environment Act, which are then inserted into the Planning Act. We don't have the more detailed guidance and regulations at this stage.
Yeah, it's maybe just worth mentioning as well, obviously what we're talking about here relates to England and Scotland. We're not having this particular regime, so the approach is rather different. That it's a policy-based approach as opposed to a legal approach. So we're not having currently anyway a legislative requirement for a set level of BNG. Rather, there is a policy expectation that developments will provide a certain level of biodiversity enhancement, but there's no prescribed level. So I suppose it's a more flexible approach up here. Although, as I mentioned earlier, we've now got some guidance that the Scottish Government's issued that puts a little bit more meat on the bones of what those expectations are. And
that's the normal way of doing these things, isn't it? Is to introduce these sorts of requirements through planning policy rather than through law. And I think it's a very different approach and a very novel approach that's being taken in England. There will be a statutory condition. The only statutory condition we've had up to now is the time limit for implementation condition, and even that has been capable of being varied on a particular basis if a local authority wants to go for longer or indeed shorter times for implementation. But here we are going to have this statutory condition that you simply can't get away from. And I think, putting aside the exemptions, most of the planning applications that I think our audience will be dealing with and will be submitting, our client base certainly would be major development, and therefore it's going to have this condition. And I guess, sort of, Michael, that in Scotland, if you've got viability issues, presumably you can potentially argue that the policy should be disapplied, the requirements relaxed, all those sorts of negotiations you'd normally have on any other policy requirement. whereas in England, we
I
just don't have that option this time.
I suppose that's right. And I mean, there are slightly different policy expectations for different types of development. So there's differentiation between major development, for example, housing developments of more than 50 units, and local development, less than 50 units. So even in the policies itself, particularly for local development, biodiversity enhancements are said to be required to be proportionate to the development. So it's very flexible and site-based. I mean, I suppose it gets you into interesting questions, I suppose, when you're looking at that kind of balance. If somebody does have a say a viability argument as to why they're trying to argue the full BUNA of biodiversity enhancement shouldn't apply, but you could have an argument with the planning authority where they're saying, well, yeah, but the habitat that you're going to interfere with is so important that we need to have a requisite level of offset or enhancement to make up for the impact that you've had. So you're going to get into a kind of direct debate about whether the development is acceptable or not, I suppose, but in the normal way.
Yeah. We've had a question come through about Wales and what the position is in Wales. Henry, do you want to talk about it? I think so. The regime we're talking about today is very much England only, isn't it?
It is, yeah. So yeah, the amendments to the Statutory Planning Act only apply in respect of England, and likewise, if you're providing off-site gain, it has to be in England. So the Scottish policy that Michael's talking about is coming in. Wales, I know, have been talking about policy, but no, I'm not up to speed on where they're at with that.
Yeah.
I'm not aware they've introduced any policy yet. I might be wrong. Don't quote me on that, but I'm not aware that Wales have yet done anything concrete.
It sounds like maybe they're going to follow a similar sort of way with Scotland in terms of a policy based as opposed to legislative approach, but I guess we'll need to see.
Yeah, because I think that's right, because it's a devolved matter, isn't it? It's ultimately a matter for the Welsh Assembly and the Welsh government to decide what they want to do. The metric you were talking about, Henry, we've sort of had various versions of the metric, haven't we? We've now got the statutory version, which reading the announcement, the suggestion is that if you've run metric 4.0, then the statutory version is likely to give you the same result. Although that didn't feel to be guaranteed to me that it was going to be the same.
It doesn't fill you with confidence necessarily. Yeah, I think as you said, the most recent version prior to this was 4.0. They've published the statutory version. They're due to publish some guidance alongside that to explain the changes. I mean, it's worth saying the metric is a relatively technical tool, so it's designed for ecologists to use to calculate biodiversity value, and essentially it spits out a value in units. Having looked at the 4.0 version before, I think one of the interesting points on that is that it splits habitat into 3 different categories. So it talks about area, it talks about hedgerow, and it talks about watercourse. And when you're delivering an uplift of 10%, it has to be in respect of each of those categories. So you can't trade between the categories. So if, for example, you've got a site where you've got a high proportion of watercourse on the existing site, you have to provide watercourse to replace the watercourse, irrespective of whether you're providing a greater uplift in hedgerow or area. I know that's caused problems on some sites that we've been looking at.
Yeah, including one where the development is a reservoir, isn't it? And notwithstanding the fact we're putting in a reservoir, actually that's not a watercourse, and therefore you've still got to elsewhere provide watercourse if that's what was there before, which is sort of slightly counterintuitive. But particularly, so I think one of the things that interests me is a watercourse is quite widely defined, isn't it? It can be as much as a drainage ditch, which might spend some of the year dry, but that is still considered to be a watercourse, and you need to replace it accordingly. So actually, the biodiversity value of a reservoir is potentially much higher than a ditch that every now and again, when it rains, fills up with water. But nonetheless, the metric places value on that lost watercourse, doesn't it?
Yeah, and I think that's the difficulty with trying to use a tool to capture all different types of habitat, isn't it? There's inevitably going to be some which fall into slightly difficult pockets.
Yeah.
And
sorry, I was just you mentioned that you said it's quite a technical thing, and I think the regulation's quite clear, aren't they? The expectation is that this will be done by an appropriate person, presumably an ecologist. It doesn't specify ecologist, but a suitably qualified person needs to be undertaking this for major development at least. I think there's potentially a capacity issue there, it seems to me, as to actually, are there enough ecologists out there to do this? Is that
Absolutely.
going to cause a problem in itself? So I think it's a good time to be an ecologist potentially over the next few years.
Yeah, and you've got to split in the metric as well. So there's a small sites metric, which will be the April 2024 developments, which can be run not sort of by a non-ecologist, but when you're looking at these larger sites, it has to be run by an ecologist. And we've been talking to LPAs in the context of sort of precedent clauses and precedent conditions. And I know one of the concerns there is very much that even if they have in-house ecologists, the sheer quantity of applications that will be coming in all in one go come January is going to be overwhelming. And there's been funding announced. There were two rafts of funding announced this year, but I think the concern's very much still there in terms of in-house resourcing and then also availability of external resourcing if you're looking to shift it out.
Yeah. And I wonder whether we'll find ourselves in a situation where developers, if they're wanting to sort of expedite their application, may well end up, whether under a planning performance agreement or some mechanism, actually paying for the local authority to go out external to have their plan reviewed, rather than it getting stuck in a queue if there is a capacity issue within the local authority. So I think that's possibly one for people to think about. It is an option if you're finding that the local authority officer just has too many of these on their desk and it's taking too long. Then there is that option to use a PPA or even a 106 agreement to pay for the for the local authority to get the input they need externally.
Yeah, and in Scotland, there's no formal requirement to use any specific type of biodiversity metric to assess biodiversity, albeit for major development, there is a requirement for best practice assessment methods, and indeed there is reference to the Natural England biodiversity metric as a current measure. I understand at the moment that Nature Scott's developing their own metric, but again, there's flexibility as to how you do it. There's a variety of different tools that are referred to in the Scottish Government guidance for how you could potentially measure biodiversity. But I suppose the point is that's just for the measurement. It's not then a mathematical calculation as to how much more biodiversity you then have to provide. And again, there seems to be more flexibility, I think, in terms of what type of biodiversity enhancement you can provide. I don't think you've got this limitation that you've got in terms of where you've got a water course, you've got to provide replacement water course. There's a bit more flexibility, although I suppose you could always get into that argument again as to whether the type of enhancement that you're providing is appropriate, given the type of biodiversity that you're going to lose. It's not going to be it's not on a legal basis that argument comes about. It's more in terms of a policy basis and whether it's appropriate in environmental terms, I think.
I always get slightly nervous where there isn't a sort of standard metric. Because at that point you then end up getting into debates where which methodology do you use? I'm sort of thinking of with your land supply is a good example of that in England, where we had debates over is it the Liverpool or the Sedgefield method, and then do you use the standard method for calculating housing numbers? All those debates could have been avoided if we'd simply had a very prescriptive this is how you do it. So that flexibility can sometimes work, but it can also just create more.
No, I agree. I think what's happened though is essentially that because of Scotland, they can't just take the English biodiversity metric and use that. They've got to have their own one, but Nature Scott haven't done it yet. So essentially, what's happening is I think the idea is they're working on developing this. Once it's developed, they will then say use this. But in the meantime, what they're saying is, you can't delay things until this is in place. You've got to get on and apply the policy and deliver biodiversity. And in the meantime, there's a number of different metrics you could use, it's a matter for best practice and discussion as to which one to use right now until there's new metrics in place, I think.
Yeah. We've had a couple of questions come in. One is whether there's an exemption for temporary planning permissions. I think the answer to that is no.
Yeah, no is the answer, as you said. I suspect that they might be caught by other exemptions. Say there's a de minimis exemption, for example, which it could be captured by. But yeah, not in and of itself.
No. And then another one's coming just in terms of looking for clarification around what happens with an application that's already in but not yet approved. If your application is submitted before the date in January next year, when the regulations come in, X date, but we think towards the end of January, if your application is in before that, then you're not caught by the statutory system. You will still be caught by any planning policy, whether that's development plan policy or MPPF. You'll still need to run through that in the usual section 38(6) way, but you won't have the legal requirement and the new planning condition, statutory condition that we'll come on to talk about in a minute. As well as you've talked, Henry, about the watercourse and hedgerows and the different types of environment, but the irreplaceable habitat is a concept we haven't talked about yet, and we probably just ought to flag up, because there's a different approach if your habitat is on the list of irreplaceable habitats, which is things like peat bogs and ancient woodland, that sort of stuff, isn't it?
Yeah, there is. So I mean, there's a fairly lengthy list of habitats that are defined as irreplaceable, so I won't go through those, but as you say, it's things like peat bogs. And what the regime does is it recognises that in respect of those habitats, just providing a 10% uplift isn't enough necessarily. So there's a slightly different approach there. And the guidance which came out alongside these regulations, so it's PPG, makes clear that the start point there is the NPPF. So the starting point is paragraph 180C, which says that development resulting in the loss or deterioration of irreplaceable habitats should be refused unless there are wholly exceptional reasons and a suitable compensation strategy exists. So rather than dealing with it under the BNG regime, it's more a question of should the development be approved, and that's a question whether that test is met or not. So that's sort of step one, if you like. Step two is then when you're looking at BNG, the guidance says that the approach should be to try and record the presence of that habitat in the first place. And then the LPA wants to be satisfied that any adverse effect is minimised, and that then there's appropriate arrangements made for compensation. So it's less restrictive, I suppose, in that it's appropriate compensation rather than a strict 10% uplift. Whether that ends up being more than 10% or less than 10%, I'm not sure. You'd suspect potentially more.
But with some very clear policy wording, I think, sitting there, isn't it? That's sort of similar to Greenbelt or AONB, where the sort of the presumption in policy is that you should not be developing
exactly
irreplaceable habitat. So you've kind of got it might be slightly less stringent later on, but first of all you've got to get over the pretty high hurdle of demonstrating that there are very, very good reasons why you ought to be developing these locations to start with. And so we got our condition, we've got our planning permission, we've got our condition. What's the next step then? Because you've got to get your plan approved, haven't you? And there's quite a lot now of detail around the hierarchy and how to approach that assessment of the net gain, isn't there?
Yeah, so I suppose what's the next step? The next step is to discharge the condition. In the explanatory notes to the Environment Act, there was a suggestion that alongside the submission of your application, you could include a draft biodiversity gain plan, and essentially at the same time as getting your decision notice, you'd have that condition approved as well. So you could do it simultaneously. In the draft regulations now, it's been made clear that you can't do that. So you have to wait until you've got your decision notice, until you can start the process, the formal process, I suppose, of getting the biodiversity gain plan approved. So I think there is an emphasis on pre-application discussions, but you have to wait until you've got decision notice to make the discharge of condition application. The application's essentially it's the same as a normal discharge condition application. You have to submit your biodiversity gain plan. There's a detailed list of requirements now in terms of what that has to cover. I think you mentioned biodiversity gain hierarchy, which is an interesting concept. So it's similar to the mitigation hierarchy in some ways, but incorporates those three options I spoke about earlier in terms of how you can provide biodiversity gain. So in brief, the first step is to avoid adverse effects in the first place. The second step is mitigate effects. And then you're looking at the three steps I spoke to earlier in order. The first one being, can you provide it on site? So that's preferable. The second one then, can you provide it off site, which is less preferable, and the closer you provide it, the better. And then the third step is statutory credits, which are very much seen as a mechanism of last resort, I suppose, and I think priced accordingly.
Yeah.
Mm.
And that's, sorry,
as I say, I suppose up here we've got it's different because it's very much that the biodiversity proposals form part of the planning application and are assessed as part of the planning application. So you're not putting it off until an approval of condition stage. You need to demonstrate what your enhancement is going to be, and then the purpose of conditions or agreements of some kind would be to secure that, as opposed to the method for delivery. So again, it's more conventional in approach, I suppose.
Yeah, and I suppose the contrast in England is some of the PPG guidance that's come out with it is clear that it shouldn't be a reason for refusal that an applicant hasn't done that step process. The condition should be imposed and it should be resolved afterwards, as long as the sort of usual legal test, as long as the decision maker doesn't have reason to doubt whether the condition is capable of being met in due course, then it should be something that's dealt with later on. So it shouldn't, unless an applicant wants to try and get as much certainty as possible up front, it shouldn't be something that's used as a sort of hurdle to frustrate the decision-making process on the grant of planning permission to start with.
Yeah, that's interesting. So I suppose in Scotland then there's the risk that the level of biodiversity that you're proposing, or the biodiversity proposals in relation to a particular site, are not considered to be suitable, I suppose could be a reason for refusal, whereas in England you're kind of putting that off until the condition stage. But I suppose you could presumably still have an argument then about whether the biodiversity proposal that you're putting forward is actually acceptable. So you might put all that money in to do your planning application, bank your planning consent, but you've still got the issue of resolving your biodiversity gain requirement.
There are a couple of areas where I can see that tension coming in terms of agreement of the plan, and the first is this concept of degradation, which is around if you have done things prior to the submission of planning application that have reduced the value of the site, then you should your 10% gain should be calculated against the pre-degradation condition of the site. And the guidance is very clear on that includes things you've done that don't require planning permission. So potentially if it's a field that's been fallow or was a wildflower meadow and then you decide to plough it up, that in itself would be potentially a degradation. It then gets quite complicated, it seems to me. I don't know what others think around sort of evidentially. How on earth do you begin to prove? And we've got this 2020 date as well, haven't we, Henry? Do you just want to say a bit about how all this fits together?
That's just seen a question coming actually on this point, which is sort of the different circumstances where this degradation provision applies. So that there are two different circumstances. The first one is the 30th of January 2020 date. So this is talking about works done without planning permission that degrade the site. So that's looking at something potentially like ploughing a wildflower meadow. It's designed to capture more cynical developers where, when they've seen the draft bill come in, have said, okay, we're going to essentially zero our biodiversity value, so that when we come to applying for a permission, we're providing an uplift of 10% of zero, which is still zero. So that's designed to capture that scenario. In the Levelling Up and Regeneration Act, so I mentioned, even though we're not covering it today.
Spoilers.
It introduces a second category around degradation, which is where if you've got a planning permission and you've carried out works after the 25th of August, 25th of August 2023, you have to rewind the clock in respect of those works as well. So that would apply, for example, if you had your existing permission, you carried out works under that permission after the August 2023 date, and you then went and got another permission for the same site, you'd be looking at the value pre those works, despite the fact they were carried out in accordance with the planning permission.
So degradation is one area where I think there may be discussions around how the condition is discharged. I think another one is around the hierarchy, isn't it? And this preference for on-site mitigation, and if not, then securing units elsewhere, and then only as a last resort the DEFRA scheme of statutory credits. I think there's clearly going to be scope for discussion there as to whether a developer's proposals in terms of their plan gets that balance right. And there'll be a tension, I'm sure, between sort of pressure to deliver on-site, pressure to deliver perhaps more locally. If you're looking at units, in theory, you can get those units anywhere in the country, but the value of the unit potentially reduces further away from the site you are. So there's all of that sort of tension, isn't there, that I think is going to play out time and time again, I'm sure, as people start to try and get these conditions discharged. And there's a really interesting point for me in all of that, which is it is far from clear, it seems to me, and in fact the PPG says completely contradictory things in two different places on it, at what point you have to buy or secure the units and the credits. There's a suggestion in some places in the legislation that it has to be done before the planning authority can discharge the condition. And that seems to me, again, that's really unusual. The idea that you've got to have bought it, you've got to have done it before you can get your scheme approved, it creates quite a tension and a bit of a risk, it seems to me. You're nodding away, Henry.
No, I completely agree, Trevor. I think it's far from clear at the moment. I think the risk is enhanced by the fact you can't transfer statutory credits once you've bought them. So if you buy statutory credits in respect of Planning Permission A, you can't transfer them to Planning Permission B. So you're very much committed at the point you've bought them, and then they're not going to be cheap. They're going to be double the price of units on off-site game sites. So it's a real cost.
Yeah. So you're going to end up having to have this, and I should say the condition is supposed to be discharged in the usual time frame for a discharge of a condition, but within that time period, you're going to have actually have quite a lot of discussion with the planning authority.
Yeah.
First of all, to make sure that they agree that you've got the right balance within the hierarchy, and that they agree that you can use credits or units instead of on site or alongside it. And you need to have you've got to have quite a high degree of certainty that the planning authority is happy with that before you go and part with the cash and acquire these things. And then once you've done that, there's still a risk, because the local authority could still change its mind because it hasn't formally made a decision by that point. So I think there's a real uncomfortable period there, I think, and it's pressure on a local authority because developers are going to want to engage in quite a lot of detail, I'd have thought, on some of this with them. Whereas normally a condition discharge, the details get submitted. If the local authority's got questions, fair enough. But if not, the paper just comes back approved. This is quite labour intensive potentially, as well as risky for the applicant who's trying to get that condition discharged.
Yeah, I think if you're an applicant, you'd almost want an in-principle decision a couple of days before the deadline. You then go and buy your credits, and then you get your approved plan back. Otherwise, the longer that period is, the greater the chance of something changing in the meantime.
And I suppose you've got to make sure as well, I suppose, as a developer, that you're being everything's done properly, being very open about everything, and there's not a risk that at a later stage the planning authority considers that the level of detail you've given hasn't been sufficient to enable them to come to a view, or you've hidden information away, and it turns out that there's actually a reason why a payment by means of credits wouldn't be appropriate in this circumstance.
Yeah. We've had a question in which is related to this point, so I'll pick up this one now. But the question is whether one can create biodiversity units voluntarily and then sell them to developers? And the answer to that is absolutely yes. That is the middle option between on-site and statutory credit scheme. You've got these units, and those units either you as a developer can create yourself, but there are, and I know we've spoken to a number of landowning clients who are looking at the possibility of creating biodiversity enhancements on their own land and then getting those units added to the register, so that they can be traded on the market and sold on the market to developers who need them. So definitely, if you are a landowner with the right type of site, this is potentially quite interesting in that sense.
Yeah, absolutely. And I mean, we've been speaking as well to developers themselves who are buying up land for this purpose, and also local authorities as well, where they've got sort of critical schemes in their area. They want to be able to come forward. They've been buying up land as the local authority with the intention they can then provide off-site gain for a developer.
So would this be working in terms of this would be, if you like, your second based approach, where you're not doing it on site, you're doing it off site. You're not going to the third option of the statutory biodiversity credit scheme, but it's the mechanism by which a developer would secure the off-site gain they require. Is that the sort of situation we're talking about?
That's right, Michael. And I think the intention is that if you as landowner are creating these improvements, you then need to secure them. I think it's envisaged that'll be through a 106. You have to secure it for 30 years. So you effectively have to covenant that you will continue to maintain that gain for 30 years. Once you've done that, you can then put it on the register, and then other developers can then can buy off the register those units from you. So that there's already certainty, because in order to get registered as a unit, you will have to have gone through the legal process of securing the retention of that gain for a minimum 30-year period. So that's how it will work, and then you'll be able to draw them down as an applicant for planning permission. You'll be able to buy them, and the intention is that the statutory credits will be significantly more expensive than the market price for units, in order to encourage people to use the units rather than to default to the statutory scheme.
I can see, I suppose I can envisage a situation in Scotland where we might start seeing a similar sort of approach to off-site provision. The guidance already recognises the possibility of, or indeed encourages, local development plans and the biodiversity policies to identify areas which are strategically suitable for biodiversity enhancement proposals. So you can kind of see in the same sort of approach that it's very much on-site first, second options off-site, and again, there'll be, if that's not something that a developer themselves has access to, there's going to have to be models developed to provide for off-site gain. The where we go slightly differently is that there won't be a formal third option of a biodiversity credit. That's just not an option that the Scottish Government's been looking at. But I can certainly see a need for a similar sort of approach in Scotland for the off-site model, albeit again, I think there's potential benefit in terms of flexibility. They don't have to be registered sites at the moment. It's very much fact and degree and circumstances.
I think it's probably worth at this point, we've talked about this kind of issue. This conversation started, didn't it, with this issue about uncertainty around the purchasing, when you've got to purchase the units and the credits. I think the position is slightly different. We've got some clarity now in the draft regulations around how an outline permission works, if that outline then allows for reserve matters to be to come forward in phases. So if it's a phased outline permission, I think that's now pretty clear in terms of the draft regulations, because it uses slightly different wording than the original wording. The way that will work at outline stage, you will have to get your overall plan approved. So there'll be a condition on the outline requiring the overall plan to be approved. That plan, you will not need to have secured the units or to have bought the credits in order to get that overall plan discharged. But then when you come to do your reserve matters for a phase, you will then need to do a phase plan, and that plan is the one that will require you, I think pretty clearly, you need to have secured your units or bought your credits before that plan can be approved, and that condition on the reserve matters can be discharged. So there's a sort of two-stage process with outline, where you'll go for an overall plan, and then the detail will come forward, and the actual purchasing and securing of units and credits will come at the reserve matter stage.
Yeah, and I think it's worth saying as well that the way that the regulations and the guidance deal with outline permissions and phased permissions is very much defining permissions as either being phased or not phased. So you could have an outline permission with reserve matters where it's not phased, and in that case the usual position would apply. Equally, you could have a full permission that is going to be phased where this phased approach of an overall plan and then phased plans would apply. So it's not necessarily a split between full permission and outline permission, it's whether it's phased or not.
Yeah, that's a fair point. I'm conscious of time, and we have had so many questions coming in, so we need to try and give ourselves time to get through them. But just one more topic I think we ought to cover before we move to trying to deal with as many questions as possible is section 73. And particularly the situation, well, there are two situations on there, I suppose, Henry. One is when you've already got a planning permission pre-January, but then you section 73 it after the relevant date in January next year. But then also just more generally how section 73 is going to be dealt with. Do you just want to summarize that for us?
Yeah, so the first scenario is straightforward. If you've got an existing permission before January and you put in a section 73 after January, it won't apply because your underlying permission, there was no requirement for biodiversity net gain in terms of the statutory regime. The second scenario, if you've got an existing permission post January 2024 and then you put in a section 73, whether or not the biodiversity gain condition will bite on the section 73 permission will depend on the effect of the change, essentially. So if the section 73 permission has the effect of changing the post-development value, for example, then potentially, yes, you'd need to submit a revised biodiversity gain plan to account for that. I think on the topic of section 73, slightly different point, but it's worth saying you can't use section 73 to vary or remove the deemed biodiversity gain condition, which you'd expect.
Yeah. No, it's got magical powers. It can't be changed.
Exactly.
Even to the point, I mean, interestingly, for planning authorities just need to get their head around this. You can't include it in the normal list of conditions. It has to be in its own newly created space on a planning permission with all sorts of magic wording. Well, I don't think we need to go into here, but there's very specific wording that needs to go around the condition that's set out in the regulations. So planning authorities need to be thinking about that, because as of some point in January, their planning permissions are going to look very different that they're issuing compared to those which they're doing today.
Yeah.
Great. Shall we try and do some of the questions then and try and get through as many of these as possible? So first question, are self-builders exempt? Self-build is up to a certain level, up to a certain number of units, I seem to recall. There is a self-build.
Yeah, so self-build, custom build are both exempt as long as it's no more than 9 dwellings on a site of less than half a hectare, and it's exclusively self-build or custom build. Yeah. So they're exempt up to a point, as you said.
Yeah. I couldn't remember the 9. I knew there was a figure, but I couldn't remember it. Well done, Henry. It's bonus points.
I've got a crib sheet, Trevor. I'm not remembering every single number by heart.
Oh, you could have just taken credit for that and looked very impressive. Interesting question around this, and this comes up so many times, doesn't it? We advise on this in different contexts. Is it the date the application is submitted or the date that it's validated by the planning authority? And I think the answer is almost always the same to this. There is no legal concept of validation for the purposes of time limits and things. If your application is valid, then the key date is the date on which that application is made. Actually, is the phrase that's used in the legislation. So if you have made a valid application, the fact that it takes the planning authorities 3 months to get around to validating it doesn't trip you up here, or indeed in most other situations. So it will be the date it's made. If your application is not valid, and if subsequently it's found not to be valid, then clearly you have a bigger problem. But if your application is valid and it meets all the statutory requirements and everything else that needs to go with it, then it doesn't matter when the local authority pronounces it as validated. This is a bugbear of mine, so I'm just going to mention it now, although it's got nothing to do with BNG. The statutory time limits for determination of a planning application apply from the date the application is validly made, not the date it's validated. And so many local authorities get that wrong. And that's important for applicants to remember, because your appeal, your non-determination appeal, runs from the end of the statutory period. So if you've miscalculated because it's taken the local authority 2 weeks to validate, you potentially lose your right to appeal without knowing it. So ignore the validation date. It's always about the date that an application is validly made, not when the local authority gets around to doing anything with it. Rant over. So if work has started on site based on an extant permission, but a new planning application is submitted to change the development proposal, can the new planning application use the pre-development biodiversity value rather than its original value, i.e. before work began? So if you're halfway through development under one planning permission, you then get another one. Where does that other one's biodiversity value start to be calculated from?
So that's the degradation point. So it depends whether the works were carried out after 5th of August 2023. So if works were carried out after that date, you rewind to before that date, even if it's under an existing planning permission.
Yeah.
If you're putting in a new application.
Yeah. And I suppose if you were breed developing at a later date, having already developed once, your baseline would be the 10% enhanced BNG, wouldn't it? You'd have to go for 10% above the 10% you've already achieved, potentially. Class Q and PD rights generally, does the condition apply to those, Henry? That's just coming back to the exemptions, isn't it?
Yeah, one of the exemptions, I think, is PDRs.
Yeah.
So you generally expect the PDRs to be captured by de minimis in quite a lot of cases anyway, but they've got their own exemption.
Yeah. A really interesting question that I think's come in is the question is meeting the 10% on site likely to move the dial in the planning balance rather than meeting it off site or via the statutory credit scheme? And I think it's an interesting one in terms of the discharge of the condition. It will clearly be relevant, and clearly the local authority will need to be satisfied that the plan gets the right balance between on-site and off-site. So at one level, yes, it moves the dial in terms of getting the condition discharged. In terms of the step before that, though, the question of the planning balance when you're deciding whether to grant planning, I suppose at that point, the whole point is you won't know, because the detail of the condition and the plan will be worked out afterwards. So I'm not sure that the plan itself will necessarily move the dial, but nonetheless, if your application includes proposals for on-site habitat enhancement, and if that's part of the planning application, it's part of the development that's going to be secured, then I don't see it. That should be, that clearly is either it's going to be ticking policy boxes and or it's a material consideration, but either way it can definitely carry weight in the process, I'd have thought.
Yeah, I agree. I think there are 2 points there. The first one is that you can submit information with your application around what you're going to do for biodiversity net gain. And the second one is that the PPG, it says that biodiversity net gain is a material consideration when determining a planning application. So if you've submitted, as you say, details for on-site gain with your application, then that's material consideration in the decision around the planning permission itself.
Will there be an expectation, do you think, from LPAs that you will do that? Because I mean, if there's effectively if there's a hierarchy that's assuming that you go for on-site enhancement over off-site, then presumably they need to be satisfied that when they're granting the application that you've actually got enough space to do that. Because otherwise, how do you apply this test? I mean, it's
there are a set of prescribed details you have to submit at the application stage as well. So there's the details for discharge condition are greater, but there are sort of outline details at the application stage as well. But I think for that very reason.
Again, I suppose it's going to be easier in Scotland because you'll have to do it at the application stage anyway.
Yeah, true.
Yeah, interesting one. Right, next question. Could BNG offsetting still be created by improving an adjacent habitat, e.g. improving a watercourse to create biodiversity gain, or a woodland management plan to improve extant woodland? I mean, the answer is yes, isn't it?
I think it's
That-
yes, but
Yeah, quite. You beat me to the butt. Go on. You do the butt.
I think the but is either you'd have to expand your red line if it was
Yeah.
adjacent so that you captured it so that it could be secured by conditional 106, or it would have to be registered as an off-site biodiversity gain site.
Yeah. That was I entirely agree, and I think if you're going to do it, you'd want to move your red line if you possibly could, because then
it'd be
you get
easier.
benefit in
Yeah.
terms of the hierarchy. You're the same thing sits higher up the hierarchy than would otherwise be the case.
Yeah.
That would be first. The other point to remember is if you're adjacent to a watercourse, and therefore you can improve the watercourse, that only works to the extent you're replacing watercourse on site. You'd need the habitat that you're impacting on site to match the habitat that you're improving off site, because you can't, as you said at the beginning, can you, Henry? You can't improve a watercourse to offset the loss of a hedge.
Exactly.
You've got to match them up, which potentially makes that more challenging.
If he hadn't included it within the red line, and you discovered that it's actually a particularly suitable place to provide the enhancement because it's right next door, so that would then need to be a registered site, would it, in order to do that?
Yeah, no, I was holding back there in case Henry was going to answer.
No, I think the answer is
You look like
yes.
you're going to. Yeah.
Sorry, yeah. Unless it's on site, i.e. within the red line, it has to be registered. So there's a natural England register for anything that's off site. So I mean, even if it's adjacent, it's technically off site. And the point is it has to qualify and it has to be able to be secured.
Yeah, I suppose I obviously we've been talking so far about 1990 development. I suppose I was thinking further ahead to NSIPs, because we've had situations with NSIP developments where the need to include or the potential need to have further enhancement of biodiversity has come up, albeit obviously at the moment there's not a legal requirement for it. But I suppose I was thinking we've had situations where we've identified suitable sites during the examination for biodiversity, which obviously at the moment those sites wouldn't be registered. And I suppose I'm wondering, thinking forward to NSIP, whether that's potentially going to be problematic for national significant developments.
I wonder whether that's why they're going with a different regime. And of course, we won't know, see what the regime is, but it feels as if with an NSIP, there might be more of an expectation that you meet this requirement up front and as part of the scheme in the way that it's sort of already done for a lot of these schemes, rather than having the units approach and the statutory credits. I think that's my prediction, is that the NSIP scheme will be much more about you having to demonstrate in order to get your DCO that you have delivered those improvements, and potentially you're compulsory acquiring land to deliver them on, and all the rest of it on you. So it's a very different beast. I think that will have to look very different than this.
Yeah. So
the reason for the registration, I think, here is because you need to have secured it. It needs to be legally secured. So you need to have one, they need to already be satisfied that the gain is a genuine gain and that something has happened within the requisite timescales to enhance the value of the land over what it was to start with. And two, you need to know there's a legal mechanism for securing it. So that would just be impossible to achieve during a discharge of condition application in anything like a sensible time. So the idea is it's all front loaded, and then once you're on the register, you as a developer looking to rely on those units can simply just buy them off the shelf, rather than having to demonstrate that those legal requirements are all met. By virtue of having been registered, you'll know that the requirements have been met. You won't need to look behind them. Any thoughts from you, Henry, on the NSIP point?
Yeah, I was just going to say that given the nature of some NSIPs, especially if you've got a big linear scheme, I know that even though the requirement's not enforced now, people are looking in optioneering at where to put things in terms of what will the biodiversity impact be in terms of the current value and what they'll have to provide as an uplift. So it's very much a factor in decision making already, I think.
Yeah. coming back to section 73, Henry, we've had a question. If I was a betting man, I'd say the person asking this question was from a minerals background by the tone of the question. But
Okay.
The question is there any guidance on what counts as an impact in the context of section 73? And the example that's given, which is where I think maybe this is minerals, is would a section 73 to extend the lifetime of operating a site class as an impact?
I haven't seen guidance, no. I think the way it would work is you'd apply the metric. So if you're looking at extending the lifetime, as in that example, you'd be looking at what was the pre-development value. So I suppose pre the original permission, assuming that permission was post January 2024, you'd then look at the post-development value of the original time-limited permission, and then you'd look at the post-development value of the section 73, and if there's a difference between the two, that's where you'd spot the difference, if you like.
Yeah. We've got a great, we haven't quite got through all the questions. Apologies if we haven't got to yours, but I think we've covered most. But there's a great last question, which we've got 2 minutes left to have a go at. If we could guess what is likely to end up in the courts on the new BNG regulations, let's each have a go. Henry, do you want to kick off? What one thing do you think will end up in the courts?
I think the statutory credits point is an interesting one. I think whether it ends up in the courts, whether it's an appeal of a discharge of condition, I'm not sure how far that goes. But I think there's certainly room for manoeuvre in terms of when do you have to have purchased your credits by, because the value of the credits means there's a value to developers in not purchasing them ahead of time. And there are the ordinary appeal provisions around discharge of condition applications. So whether that goes to the courts, I don't know, but I think there's potential for an appeal, at least on that.
There's certainly potential for appeals all over we'll see. I think we'll see a lot of appeals against refusals to discharge conditions, which are quite rare. We don't see those very often, but it feels like there's a lot of those that are going to come as this system beds in. Michael?
I'm going to go with something slightly different. Yeah, I suppose I'm thinking more in a kind of Scottish context. Things don't tend to go to court as much up here as they do down south. I think what we might have are, rather than legal challenges, I suspect, well, because of the nature of the system we're having, which is inherently more flexible, I can see a situation where we're going to have more appeals, where biodiversity net gain or our equivalent to it is going to be the issue which is in dispute. That's what I'm thinking.
And I think I went last, which felt very generous of me to let you guys have the pick of the crop. I think for me, one of the other areas, there are a few, but for me, one of the other areas is going to be around this question of degradation and around evidence and trying to establish whether something has been degraded. If so, what is the correct number? That feels like there's some litigation there yet to happen.
Yeah, and on that point, before we finish, Trevor, there's the LURA introduced this wording, which is saying if you can't determine that, the pre-development value should be the highest biodiversity value, which is reasonably supported by any available evidence. So if you want something to dispute, that's a great sentence to dispute.
Yeah, and I think we've said previously, you need to be gathering evidence as to what the biodiversity value of the site is now, so that you've got that evidence available later. But we are at time, we are bang on the hour, so we'll end it there. Henry, you've left it with a reference to the LURA, so that's a good point for me to say we will be back on the 25th of January with the LURA session. So if you sat through this wondering why we didn't talk about the Levelling Up and Regeneration Act, we will do that next month instead. So do join us again on the 25th of January. In the meantime, thank you, Henry, thank you, Michael, for joining me today, and happy Christmas to everyone. Thank you and goodbye.